Okay. All right. So I think I'm live now on Facebook and YouTube. So sorry, guys, I'm doing a do-over again. Welcome, everybody. YouTube, Facebook, Instagram. My name is Aisha Chidole. I'm talking about all things immigration today. Specifically today, I want to talk about adjustment of status and some of the proposed changes that most likely will take effect unless something else happens. One of the things that I said to the followers on Instagram is, I generally don't like to bring speculation until they become rule or they become a proposed rule because, I don't ever want to be an author of confusion or to make people have more fear for sensationalizing something. So me bringing this to you today is because this is something that is most likely going to pass. What I want to talk about is adjustment of status and what it's going to look like. So last week, sometime, the current administration proposed to rescind. I'm going to try and speak this in as plain English as possible. They put forth a proposal to basically remove what the previous administration, the Biden administration, had in 2022 under their own public charge rule. You might ask, well, what is a public charge rule? What does that mean? It basically means that if you are someone applying for adjustment of status, if you don't qualify for certain exemptions, which I'll get into in a second, you cannot be someone that has a high propensity, a high potential to be a public charge. What does a high potential to be a public charge? It means that you need a joint sponsor. You've taken public benefits. You don't have a stable job. What is your educational history and things like that. So prior to Biden entering into office, President Biden entering into office, you guys probably have heard me talk about this because I talked about this a lot before Trump entered back into office, because this was in Trump's first administration. They called it's the public charge rule or the wealth test. It's the wealth test. And I'm going to go into the requirements in a second, right? And that wealth test, when Biden entered into office, he removed it and basically said, the only things that they're going to really consider, to determine if someone is a public charge is they're really going to look more on like long-term, like they're going to look at long-term benefits, like long-term care, like and you saw governmental aid and things like that. But this new proposed rule is basically saying that is too narrow. And we are going to make it broader and essentially bring back President Trump 1.0 rules of public charge. So what does that look like? It means that if you are applying for adjustment of status, these are potentially what they want to look at. And basically they've put this proposed rule out and they give you a window, they give us a window to all comment and for public to comment and give their opinions about it. And then after December 22nd, I want to say it's December 22nd, it becomes the rule. So basically, if you are someone that is on the slippery slope, you want to file now before it becomes rule. Because once it becomes rule, you'll be subject to that new rule. So think about it this way. It's the wealth test. There's a 7-factor. It's been a long time, so I'm going to try as much as possible to remember everything. So basically, this is some of what they look at. So they look at certain things that are going to be considered as positive factors, and some things that are going to be considered as negative factors. So I'm going to start with the negative factors. They're going to look at things like income. Are you from a low-income household? Are you going to do you have limited education? What is your ability to speak English and to get a job, right? They're going to look at things like, have you ever taken SNAP benefits? I see someone ask that question, right? So they will look at that if you've taken SNAP, whether it's for your children, whether it's for someone else in your household. As long as that person is in your household, they're going to look at things like, do you need a joint sponsor? What does your joint sponsor contribute, right? And then the things that they're going to consider as positive factors would be, people from high income, you have private insurance, you have advanced education, you've got strong English skills, you have savings, you have assets. Basically, they're going to bring, or they're wanting to bring these back, and basically giving USCIS officers, a broad scope to be the ones to make the decision. So I say this to say that not one thing here is going to get you denied or approved. They just it's like a ranking system where they're going to basically say, this is a positive factor that you have, this is a positive factor that you have, this is a negative factor that you have. For instance, like if they say, okay, this person has, all these health conditions or whatever it is, but then they see that they have private insurance, or they see that they have a reasonable income, then that can kind of like cancel that out, right? If you have, if your English maybe is not as strong, but you've shown stability, in your job, you're not taking public benefits, you're not doing any of all those things, then that is also something that would cancel it out. So it's really important that, you guys, think about these things when you're putting your applications. Generally, there's certain case types that will be exempt from this. Some examples of case types that are exempt from this would be humanitarian-based cases, like VAWA cases, T trafficking visa cases, U visa cases. Those types of cases are generally exempt because those are humanitarian-based cases. So they were exempt in, the last administration, and will also be exempt in this. This is really for those that are applying for adjustment of status where an I-864 financial affidavit of support is required. So that's how to think about it. If an I-864 financial affidavit of support is required for your application type, you will not be exempt from this. You're going to need to provide this. Again, this rule has not been put into effect. I want to be very clear because I don't want anybody to quote me saying, Aisha said that this is the rule. This rule is not yet in effect. This rule has been proposed. There is a window where the proposal has to kind of go through public commentary and all of that. And once that is done, depending on what commentary they get, they could pass this rule, or they could continue this rule. So what does that mean for those of you that are in the application process? If you are in the application process already right now, you're not subject to the new rule, right? You're subject to the 2022 President Biden's rule for adjustment of status. Anyone who applies before the rule takes into effect will also be subject to the 2022 rules. So if you are in the process, getting your applications now so that you can lock in your date before this becomes rule, should it become rule. The reason why, for me, I'm talking about it now is because, one, you have a window of opportunity to apply. Number two, because we know that these were things that were in the previous administration, they call it public charge rule, or some people call it the wealth test. So because those things happen in that administration, the odds are that it will happen again. Quite frankly, I think it's actually a little, it's been a little, it's taken longer than I thought it would, to be honest with you. I thought it would take, a shorter time. So make sure that you have your ducks in a row, and you're doing whatever you need to do. Okay. All right, let's get right into it. Zarahel, thank you, Grammar Police. You can log off or, get off the live if my lingo bothers you. Okay, let me answer some of your questions. I'm traveling this week with a green card for 1 month. I'm not sure if you're asking me a question, but as a green card holder, you are permitted to travel, and 1 month is not a red flag or does not indicate in any way that you are, abandoning your green card status. Okay, let's see what else I have. My phone keeps ringing. I don't know if it's disrupted my audio. You guys can let me know if you can still hear me. Someone says, does this apply if you've gotten married? This rule is going to apply. It's not, remember, it's not yet the rule. It's a proposed rule. They proposed this rule. But again, it's going to apply to those who are applying for adjustment of status. Adjustment of status means that you're applying for a green card, right? Adjustment of status means you're applying for a green card and you're subject to the public charge rule. Who are the people subject to the public charge rule? These are going to be people who have to submit an I-864 financial affidavit of support. If your application type certain humanitarian cases like asylum, VAWA, T visas, U visas, those people are not going to be subject to the public charge rule because they don't generally submit I-864. If you have a 48-month extension without the green card, can you still go to Jamaica without no problem? Going to Jamaica is really going to depend on what your current status is. So one of the things that I always say to green card holders who have 2-year conditional green cards, which is essentially what you have, is, well, what did you apply for? Did you apply for a joint filing of removal? Are you and your spouse still together? Is there infidelity going on in your marriage? Have you guys separated? You want to think about all those things and make sure that whatever your current status is what is reflected in your application that you've submitted. Because if it's not, you put yourself at risk that they may, call you into secondary inspection. Them calling you into secondary inspection doesn't necessarily mean they're going to say, okay, go back home. It's just that you're definitely going to be going through a more rigorous entry process. The other thing that I always say to people is, what kind of arrest records do you have or arrest history? There used to be a time where, you submitted your arrest and it wasn't a crime of moral turpitude and you got your green card. Now, you really want to make sure that whatever your history is not something that can cause them to stop you from entering or place you in deportation proceedings. So while this has not happened to any of my clients personally, because most of my clients know that at our firm, we have a policy that, once you retain us and we get you any travel papers or your green card, it's always good and prudent to reach out when you want to travel so we can just make sure based on your status, we can say, it's most likely safe for you to travel or you should wait this one out. So I have a colleague whose client who got a green card, reported the crime, she gave them their criminal disposition from 15 years ago, traveled, and then they came back into the United States and they were detained. So ultimately she was released after, I think a month or so. But just that process was very traumatic, especially because she had a green card and because she had every right to leave the country. Someone is asking, misrepresentation but inspected, does this count as a legal entry? Yes, it counts as a legal entry as long as you were inspected and you have an I-94 proving that you were inspected at entry. Misrepresentation can be a bar to getting a green card if you're not eligible for a waiver. So the first question you need to be asking is, whatever your misrepresentation is, are you eligible for a waiver? There's certain misrepresentation that depending on what you're filing, you're not eligible for a waiver. For instance, if you ever falsely claimed to be a United States citizen, then you will not be eligible for a waiver for many case types. So that's an example of a waiver that you won't be able to get, okay? Okay, let's see, what other questions do we have? This is a good one too. Does the public charge rule apply when you file for naturalization or just green card applications? The public charge rule only applies to green card application. It does not apply to naturalization applications. Someone is asking, what is a call-in letter? A call-in letter is the exact same thing as an interview letter. Some field offices call it a call-in letter. You'll find that mostly in a lot of I-751 cases and sometimes some VAWA cases, especially when the file moved from one field office to another field office. But a call-in letter is basically an interview letter. Someone says, I was told in my dream that you are my sister. That's funny. I only have one sister, but that's funny. Okay, let's see what else. All right, guys, I'm just looking for questions that I haven't already answered. Okay. How long does it take after applying for citizenship to get an interview date? The answer depends on your location. So certain locations are super quick. Well, actually, honestly, everyone is really quick right now. But what I mean when I say some are super quick, like where you apply and it takes about 2, 3, 4 months, and then other locations could be 6 or 8 months. But generally right now, in a lot of the cases that we're submitting, we're seeing that they're moving really, really fast in scheduling interviews. So that is a good thing, like it's funny because, I know people sometimes say, oh, my case is taking so long, my case is taking so long. And then when they get this interview scheduled super quickly, they're like, oh my gosh, why is it so quick? So I say that to say for naturalization, it could be anywhere from like 2 months to 9 months. That's kind of what we're seeing right now, with most people falling somewhere between 6 and 7 months. For applications for green cards that you applied, I want to say from February 2025 to date, we're also seeing that those cases are being processed much quicker. So they're being scheduled for interviews within 6 to 8 months, a lot of those cases as well. I know that there are people who applied before that are going to be like, well, how come mine hasn't been scheduled? Again, I'm only talking about cases that were applied for from February 2025. Those cases are being adjudicated faster. And, because USCIS has created new service centers, they're now calling them SCOP, SCOP, who are processing these and giving out the receipts quicker. That's more recently. So for those people, they're going to see the adjudication faster. And those receipt notices that started coming quickly started in September, because I know there are going to be those of you that are going to be like, well, I submitted my case in April and it took 4 months. Again, those were for those cases, any cases that were submitted, especially humanitarian-based cases that were submitted after September, when they changed the service center. Those cases are getting their receipts really quickly. Sorry, guys. I'm still recovering from my cold, so it's hard to talk for a long time. Okay. Last June, in June of 2025, I did an I-130 for my spouse. We will need to do a 601A. Once it's approved, it will be a while. Are we subject to this rule? If it passes, my handicapped child is on Medicaid for therapy. Again, I just want to make sure you remember that this rule has not passed yet, and this rule applies when you're applying for adjustment of status. This is specifically what I'm talking about, adjustment of status. If you are doing a 601A waiver, what you will be doing is consular processing, meaning outside the United States. We don't know yet, or we've not received any notice on what they're going to do on the consular side, but in this administration's first go around in 2016 to 2020, they had a consular version of this, so it's possible, but as of today, the answer is it doesn't exist. So I can't tell you if it will happen or not, because it doesn't exist. Someone said my extension is up. What do I do next? If you were talking about your I-751 extension, what you do next is you schedule an info pass with USCIS, and you specifically request an added stamp, ADIT. So basically that is them putting a temporary 1-year green card stamp on your passport while your case continues to be processed, and while it's still pending. I have a 10-year green card based on VAWA. Can I file for my wife, and can she get work authorization without leaving the country? Well, the answer is really going to depend on your wife's status, okay? It depends on your wife's status. When did you get your 10-year green card? That's number one. Number two, if your wife is out of status, she will not be eligible for adjustment of status while she's in the United States. You, as a green card holder, the only person that you can file for an adjustment of status while they're in the United States, they must meet two criteria. They must be in status at the time you file for them, and the visa bulletin must be current. Speaking of the visa bulletin, and good news about the visa bulletin, the December visa bulletin is out, and so anyone basically who filed their I-130 prior to November 22nd, 2025, the visas, and you're trying to adjust your status, meaning here in the United States, the visa bulletin is correct. So if you have a receipt date of November 22nd, 2025 or earlier, you would be able to file for adjustment of status after December 1st. If you are a VAWA applicant and you're married to a green card holder, if you submit your VAWA application, or if you submitted your VAWA application before November 22nd, 2025, you will finally be able to add your adjustment of status application as of December 1st this year. If you're a VAWA applicant and your spouse filed an I-130 for you, but that case was denied or abandoned, you can use that receipt number if it was before November 22nd, 2025, to apply for adjustment of status under your VAWA, even though you were married or are married to a green card holder. All right, guys, I gotta jump off. If I didn't get to your question, sorry about that. Definitely schedule a consult, and I'll be more than happy to give you focused time to answer your question. Again, our number is 407-995-6567 or 678-325-1037. You can also send a WhatsApp to 404-333-8751. The information is also in my profile on Instagram. There's a blue check mark, so you know it's my account. It's also on the ticker in Facebook, and what else am I on? On YouTube. I hope you guys have a great day. Again, if you're eligible for something, file. Immigration moves so quickly, the laws change so quickly, but a lot of times when you file before the laws change, you lock in whatever the law was when you filed. I hope you guys have an amazing and blessed Thanksgiving, and I pray that you guys all have something to be thankful for. If you've had a really tough year, I pray that it's the beginning of better days to come for you, and I will talk to you guys later. Bye.